All right? Yeah, fine.
Good morning, everyone. I think we'll make a start. You're very welcome to the publication of the independent review by Angus McCullough, KC, of PSNI conduct relating to covert measures against journalists, lawyers and others of special status between the 1st of January 2011 and the 1st of November 2024. I'm Sinead Simpson, the Chief Executive of the Policing Board, and I'll be facilitating this morning's media launch, which is also being live streamed. Just a few housekeeping arrangements to run through. There are no fire or other alarms scheduled, so please follow the directions of staff if an alarm sounds. And if I can ask you all to make sure that phones are now placed on silent. So the order for today's event is as follows. The Chief Constable will give a short introduction in a moment to the report, after which Mr McCullough will present his report. Then Mr McCullough will be joined by the Chief Constable, by Mukesh Sharma, the Chair of the Policing Board, and by the Board's Human Rights Advisor, John Wadham. Both the Chief Constable and the Chair will give their comments on the report's findings, and after that there will be a chance for questions and answers. So thank you for attending this morning. Can I now invite Chief Constable John Boucher to say a few words? Thank you.
Thank you, Sinead. So, in June of last year, as a result of concerns raised by various bodies, including the Northern Ireland Policing Board, and following an internal PSNI report that I commissioned to examine the use of covert measures in the PSNI against journalists and lawyers, I then commissioned Angus McCullough KC to undertake an independent review into conduct by the PSNI arising from concerns raised in relation to surveillance of journalists and other special status groups. This review is entirely independent. I'll shortly invite Mr McCullough to provide some opening remarks about his report, which I am publishing this morning. Once he's finished his remarks, I and the Chair of the Policing Board, Mukesh Sharma, and our Human Rights Legal Advisor to the Board, Mr John Wadham, will join Mr McCullough on the stage. I and the Chair will then provide you with our responses to the report, and then we'll be very happy to take questions. Okay. Angus.
Chief Constable, thank you. Good morning, everyone. As you've heard, my name is Angus McCullough. Thank you to the media representatives for being here and to all those who are following these proceedings online. I was appointed by the Chief Constable to conduct this independent review in June of last year. Having formally submitted my report to the Chief Constable, I am very pleased that it is being published by him now, today. This is the main report of the review, although if my first recommendation is accepted, it will not be the last. The report should now be available to download on the PSNI website, as well as on my review website. I think those in the room will have seen it. It is a long document running to some 200 pages, and I would emphasize that it is necessary for anyone wanting to have a proper understanding of my findings and the recommendations to refer to the complete report. For the purposes of today, it may be helpful to provide a brief introduction to that report. On the morning of the 31st of August 2018, 2 journalists were arrested in their homes in Northern Ireland. Their houses were searched, as were the offices of the film production company with which they were involved. Large quantities of equipment and documents were seized, and police officers undertook a surveillance operation of a person thought to be their source. The investigation was led by the Durham Constabulary, who had been brought in by PSNI, but it is clear that there was operational input from PSNI itself. Those 2 journalists, Barry McCaffrey and Trevor Burney, had been working on a documentary called No Stone Unturned about the Loughin Island murders, an atrocity in which 6 men were shot dead and 5 others injured in a UVF attack on a village pub in 1994. Nobody has ever been prosecuted for those murders, and the work of these journalists included investigation of allegations of state collusion. In subsequent legal proceedings, it has been determined that the search warrants and the authorization for the surveillance operation were unlawful. It also came to light that in 2013, while working on a different investigation into alleged illegal payments to a senior official within PSNI, billing data for Mr. McCaffrey's work phone had been authorized to be obtained covertly. This was admitted to have been unlawful by PSNI, although they were applying the statutory guidance that was in place at the time, which in 2015 was remedied to set out additional protections for journalist sources. There was understandable concern and in some quarters understandable outrage at these events. 2 journalists who had been investigating mass murder and allegations of state collusion had been arrested and subject to covert measures and surveillance of a suspected source. The warrants and authorizations under which this was done were found to have been unlawful. The concerns were not just about the implications for Mr. McCaffrey and Mr. Burney, serious though those obviously were. They were also about the chilling effect that this could have on investigative journalism in Northern Ireland. The right of freedom of expression, including the freedom for journalists and civil society to examine the actions of the state, is fundamental to democracy. It is also of vital importance that public confidence is maintained in the police and in the processes by which officers conduct covert operations and surveillance. It is clear to me that this disturbing episode has been a major cause of loss of trust in the police in this area. There are parallel concerns of similar gravity, although without such an obvious triggering event, as to whether lawyers and the rights of their clients to have privileged communications with those lawyers may have been abused in the exercise of covert measures. Respect for legal professional privilege is an aspect of the rule of law and another tenet of a free society. All that is a significant part of the background to my having been asked to conduct the independent review that has led to this report. I say at the outset that there are some cases that are under continuing consideration by the Investigatory Powers Tribunal, and those currently fall outside my remit under the terms of reference until those cases have concluded. That position has been clear from the outset. It is set out in the terms of reference. And on discussion with the advisory group, about which I will say a little more in a moment, these cases were excluded from the remit of the review under my terms, but only for so long as they are ongoing before the statutory judicial body, the Investigatory Powers Tribunal. And that is for reasons which, insofar as they are not self-evident, have been explained on the website and are now also reiterated in the report. Some relevant IPT cases have concluded over the last year and so have fallen back within my remit, and we have looked at them. One person took the decision to withdraw their IPT claim so that I could consider it within the remit of this review rather than deferring such consideration. I have followed the cases that are currently ongoing and made a proposal for them to be considered by me once the IPT proceedings have concluded. But it did not seem to me to be appropriate or in the wider public interest to delay publication of this report as soon as it could be achieved. I don't want to say much about the method and approach that we have adopted in conducting this review because it is set out in considerable detail in the report. As school children, we were often told in exams to show our working. We in this review have sought to show our working, and it is set out, as I say, in detail in the report, so that the thoroughness of the exercise and the basis, as I would suggest, for confidence that we have reached robust and reliable conclusions is apparent. Findings. What have we found? At the outset, I would highlight that in Part L of the report, I have set out and seek to address and clarify various matters which have been misunderstood or misreported in the coverage relating to the subject matter of the review or the scope of the review itself. In doing so, I fully appreciate that there are particular challenges in reporting these matters arising from the difficulty in accessing any, let alone complete and verifiably reliable information. So in putting forward that part of the report, I make no criticism of the journalists and their work in this area. But I hope that section is of assistance to reporters who I know will be doing their best to provide accurate and balanced coverage alongside my detailed findings. It really is necessary to read the full report for a proper understanding, but for now, the following headlines, and they are no more than headlines, in relation to matters within my current remit under the terms of reference, so as I've made clear, excluding particular cases that are ongoing before the Investigatory Powers Tribunal, I highlight the following. First, assertions in some quarters that PSNI have been conducting systemic wholesale surveillance of journalists and lawyers are misplaced. Our detailed searches provide no support for concerns at that scale. Second, the corollary of that is that where covert measures are being deployed in relation to the groups under review, they are largely being lawfully applied, properly applying principles of necessity and proportionality in recognition of the sensitivities in these particular areas. The report includes a detailed breakdown of the applications, authorizations, and investigations in each category to help understanding of the different ways in which the powers may be exercised and why, in most cases, I have reached the view that they are being appropriately exercised. Third, this is complicated. Any proper understanding of what PSNI has and has not been doing in relation to areas within my remit requires specificity in the identification of the particular covert powers involved and understanding the nature of those, the purpose of the application of any such power in any particular case, the risks of obtaining sensitive information collaterally, and the safeguards put in place. All this can quite easily be lost in any discussion. Furthermore, it is complicated by the fact that the legislative regime has changed significantly during the period under review, and there have been repeated changes to the relevant statutory codes of practice which the police and other law enforcement agencies are required to apply. At the risk of what may be an unduly lengthy report, I have done my best to unpick those various aspects with the huge assistance of my two assistants in order to facilitate an understanding that is not always easy to extract from the headlines or the press reports. Fourth, by far the most widely used covert measure is obtaining communications data. It is important to appreciate that the obtaining of communications data does not involve accessing the content of any communications and technically does not constitute surveillance, but it is a significant intrusive power. This is explained in more detail in the report, but it is essentially records of numbers connected with times and durations of a call or text, and it may be associated with subscriber information. As I say, it is an intrusive measure, but far less intrusive than some other covert powers. Of course, it must be exercised lawfully, which in essence, in this context, means only when necessary and proportionate and with proper safeguards. So fifth, and turning to the specific headlines of the findings, and I advance these in particular categories. Firstly, communications data, and I made clear what communications data does and doesn't involve, relating to journalists. The report identifies some specific cases in which I consider the covert measures are likely to have been authorized unlawfully. These involve 7 journalists in cases with authorizations to obtain communications data to identify a journalistic source. All these cases predate 2015 and were in a period in which it is now recognized that the statutory code of practice in place was deficient. Those journalists, apart from one who has sadly since died, have been notified. And I should make clear, these are in addition to the case of Mr. McCaffrey that I have previously referred to, also predating 2013 in relation to the communications data obtained in his case. Next, communications data for lawyers. I have identified one case, but involving more than one lawyer, where the consideration of legal professional privilege was, in my view, inadequate to a degree that I doubt the legality of the authorization in that case. Those lawyers have been notified by me, with, I should say, the approval of the Chief Constable. Next, directed surveillance applications. Now, directed surveillance is, of course, an intrusive power. By definition, it is not a power that is exercised in an individual's home to conduct surveillance in an individual's home or car, and there are various other protections. But broadly speaking, that more intrusive surveillance is labelled intrusive surveillance and is distinct from directed surveillance. I've found no instances of intrusive surveillance within my remit in the time period. Apart from the directed surveillance authorization seeking to identify Mr. Burney and Mr. McCaffrey's source, we have identified 2 others relating to journalists. One I consider to have been entirely lawful. The other relates to the well-known investigative journalist Donald McIntyre and is considered in detail in the report. And it will be seen that I have considerable concerns about the process adopted in that case. Next, directed surveillance applications involving lawyers. I have identified 2 separate DSAs, as I will use the abbreviation, involving the same lawyer, both of which I consider likely to have been unlawful for different reasons, as explained in the report. That lawyer has been notified. In addition, I am aware of an issue in relation to the conduct of surveillance in courthouses, which does not relate to any particular lawyer, but I have concerns relates to cases which have not been authorized at the appropriate level, and there is a recommendation in the report in relation to that potential practice. And lastly, in relation to the categories, covert human sources. In the report, I identify some issues in relation to the authorization of human sources, where I have queried aspects of the authorization process or conduct in relation to the product. These are not susceptible to notification for legitimate reasons of source protection. However, these findings have fed into my recommendations. Aside from these specific instances, we have identified areas of practice which I believe could be significantly improved by a more consistently secure understanding within PSNI and those responsible for operating these procedures of the difficult areas, of the difficult issues involved in relation to confidential journalistic material, journalistic sources, and legal professional privilege. Finally, and not involving the exercise of any covert powers, we have identified a particular issue with a practice within the Professional Standards Department which involved the wholesale cross-checking of journalists' numbers against PSNI communication systems logs. Those numbers may have been openly available or entirely legitimately obtained, but the concern arises that the use to which that personal data was put may have been non-compliant with data processing legislation, and that is the subject of a specific recommendation. I should say that practice has now been stopped, and the timing is set out in the report, but it was ongoing for a considerable number of years. I'd like to highlight some features of the review which I believe have contributed to the process being robust. Firstly, I have had the benefit, the enormous benefit, of a group of experts and stakeholders with whom I have consulted regularly throughout the last year and a bit. They have been involved throughout as a source of invaluable advice and discussion, from the drafting of the terms of reference to reviewing the draft of the report, and at all stages in between. The individuals are listed in Appendix A of the report, as well as on the review website, from which it can be seen that they bring vast experience across a range of relevant areas: journalism, law, human rights, and the holding of state bodies, in particular the police, to account. I bear sole responsibility for the work of the review and its conclusions, but I pay tribute to the contribution that this group has made to the review through their advice and guidance. Next, the terms of reference. I think it's worth making clear that I was given an entirely free hand to draft my own terms of reference. I produced that draft in close consultation with the expert advisory group. The remit, as far as subject matter is concerned, the dates of the period under review, the groups to be considered, and the exclusion of matters that were the subject of ongoing IPT proceedings were all proposed by me after discussion with the advisory group. The Chief Constable agreed to my proposed terms of reference without any amendment, restriction, or limitation. Next, the degree of access which I have had. I consider it a remarkable feature of the review that I and my assistants have had direct, unsupervised access using anonymized logins to every PSNI system and repository of information that we have sought and that holds potentially relevant information. That has been the case throughout our work conducting the searches to establish the facts of surveillance and covert measures within our remit. Nothing has been withheld from me or my team, not on grounds of sensitivity, legal privilege, asserted irrelevance, or any other basis. It is hard to imagine such access being afforded to any public inquiry which would be dependent upon PSNI being required to produce documents that such an inquiry requested. I should next mention the commitment of the Chief Constable to this review. I acknowledge that from the outset and throughout, John Boucher has given full support to me and my work in ensuring that the review is as thorough and effective as possible. Every request I have made has been promptly granted, and from the earliest stage it was apparent that his officers and staff had received the clearest message that the review should be given prompt and total cooperation. And I can confirm that that is what has been provided. This commitment from the Chief Constable has included his assurance to me at the outset that he shared my intent that the work of the review should be maximal in its transparency, in its work and its findings, notwithstanding the sensitive and covert nature of the procedures under investigation. Every individual that I have proposed to be notified, and I've summarised them in my remarks previously, has been agreed by the Chief Constable. There is nothing I feel I could properly have included in the report which I've been required to omit. I have been able to produce a report that is entirely open, in that all findings, reasoning, and recommendations are in open. The only matters in a closed annex are identifying details of cases that have necessarily been described in the report only in general terms, for reasons that are identified and expressed in each case. And finally, in relation to these features, I would note the cooperation from others, not just serving PSNI personnel, but everyone that I have approached has fully engaged with my requests for information and assistance. As described in the report, only 2 people have not been in a position to assist for what I consider to be genuine reasons and are identified in the report. I'm aware of some suggestions that my work would be inhibited without powers of compulsion, but I can unequivocally state that has not been the case. And so to my recommendations. There are 16 recommendations in the report. If implemented, I feel confident that these recommended measures will assist PSNI in attaining greater consistency of high standards and optimal practice. My team and I have found the officers and staff who are responsible for compliance in relation to covert measures to have an openness and shared aspiration that makes me optimistic that these high standards will be achieved. In turn, this should enable journalists, lawyers, and other groups within my remit to be confident that PSNI is consistently acting lawfully and proportionately in these most sensitive and important areas. So, in conclusion, I wish to pay tribute to those journalists, lawyers, and members of civil society and others who have responded to my requests for engagement and evidence. We received 55 completed questionnaires. These are analysed in some detail in the report, on a confidential basis. Many other individuals have also engaged with the review and helped to inform my understanding of the issues involved and enhance the confidence I can have in the findings and recommendations I've set out in this report. I am very grateful to all of them for their time and trust in this process. Among that number are Mr. McCaffrey and Mr. Burney, whose experience, skill and tenacity have been central to bringing greater scrutiny to this area. What they underwent as a result of PSNI's failures was as clearly unjustifiable as it was unlawful. However, our detailed work over the last year and more enables me to conclude that the serious failings by PSNI in their case were not typical. Their case does not represent the tip of an iceberg of illegality or wrongful surveillance. Looking forward, my recommendations are intended to help ensure that their experience is never repeated, that the public can have confidence that covert powers exercised where sensitive professions, such as journalists and lawyers, are involved, are carried out to the highest professional, legal, and ethical standards. Public trust is easily lost and hard to earn back. I believe that this review provides a prescription for PSNI to earn back trust that has been lost. My personal experience in conducting this review, since being appointed 15 months ago, gives me real confidence that this Chief Constable and his officers have the determination to do just that. Indeed, I believe they know they must. Thank you.
Thanks very much, Angus. Can I now ask the Chief Constable, the Chair of the Board and the Board's Human Rights Advisors to take their seats up at the table, please? Thank you. Okay, so now we're going to have a response firstly from the Chief Constable and then from the Board's Chair, and then we'll turn to the questions, a list of which I have in front of me here. Chief Constable, over to you. Thank you.
Thank you, Sinead. Thank you, Mr. McCulloch. Good morning again, everyone, and thank you for coming. As Mr. McCulloch has explained, in June of last year, I commissioned him to conduct an independent review of any PSNI covert surveillance against journalists, lawyers, and other non-government organisations between 2011 and 2024. I want to thank Mr. McCulloch and his team for the rigorous and professional review that they've carried out. I welcome their findings and absolutely and entirely accept all 16 recommendations that they have made. I also want to acknowledge the contribution of the group of experts and stakeholders whom I spoke to in advance of the review being commissioned. Their assistance and that of the Policing Board's Human Rights Legal Advisor have been immensely helpful and important to this work. Throughout the review, we ensured that Mr. McCulloch and his team had direct, unrestricted and unsupervised access to PSNI systems and staff. His report describes this level of access as remarkable, and in my view, it is unprecedented. I was and remain determined to achieve full and complete transparency, and I truly believe that we've achieved that in this review. I very much welcome the key conclusion that there is no basis for public concerns that PSNI has been using covert measures in respect of journalists or lawyers in a widespread or systematic way. As with any such forensic review, deficiencies were found that have resulted in Mr. McCulloch making a number of incredibly insightful recommendations. These recommendations will all be advanced through a timely programme of work to ensure we constantly achieve the highest of standards in the application and authorisation process for covert measures being undertaken. The wider concerns of a perceived systemic abuse of our use of covert powers can be traced back to an investigation as described by Mr. McCulloch, led by Durham Constabulary, in which 2 journalists, Trevor Burney and Barry McCaffrey, were arrested and their property searched in August of 2018. It subsequently became clear in the course of legal proceedings that warrants issued for the searches and for other surveillance activity were unlawful. I again profusely apologise for those mistakes and those actions that were taken. I do not underestimate personally the impact on them and of their families. I am certain those officers involved would act entirely differently today. Journalism is an incredibly important profession that I strongly support and has provided the truth when it has been out of reach to victims, especially in the Northern Ireland context. A free and effective press is a vital component of a healthy and well-functioning democracy. Good journalism holds government and the establishment to account, including the police. It should be nurtured, not obstructed. I'm very conscious that this story began with Mr. Burney and Mr. McCaffrey's investigative programme, No Stone Unturned. Northern Ireland legacy families I know personally have relied hugely on responsible journalism and such programmes for answers. These experiences of both men have now been dealt with appropriately in the courts, with findings rightfully in favour of both Mr. Burney and Mr. McCaffrey. I again apologise to both of them for the failings that occurred. I've also recently written to them and offered my sincere apologies that data derived from their electronic devices seized in 2018 searches had not been deleted. It now has. I've offered to meet both men to discuss the matter personally with them. However, just because we got it wrong with Mr. Burney and Mr. McCaffrey in 2018 does not mean that there's been widespread abuse of covert powers. This report makes absolutely clear that it is not the case. As such, I do not believe there are grounds for a public inquiry on this issue. The McCulloch Review has rightfully shown examples where there have been deficiencies, failings of process and record keeping. Frankly, any large organisation undergoing this level of legal scrutiny should expect such issues to come to light. Although not part of his terms of reference, from my reading of the report, there is no finding that officers acted in bad faith or referencing of any misconduct or criminality. I welcome this and assure you all we will learn each lesson identified from this review. We use covert powers to protect the public from all sorts of serious threats to society, of organised crime, terrorism, paedophile rings and drug dealers. They are essential powers, and it's vital that they are used properly and lawfully with all due consideration of special status groups, including lawyers and journalists. There will no doubt be a tendency for some to focus only on where we got things wrong in the review. However, I've been reassured by what Mr. McCulloch describes as the proper emphasis on the far more numerous examples of careful and considered practice, processed by diligent professionals in full accordance with the legal framework and its safeguards. I hope the Policing Board, the public and those affected will be reassured by Mr. McCulloch's findings of there being no evidence of systemic use of covert measures being deployed by the PSNI against journalists, lawyers or other special status categories. It's also positive that he's confident that the measures he has recommended will assist the PSNI in attaining greater consistency of higher standards and optimal practices. He states that he found officers and staff to have an openness and shared aspiration that these high standards are achieved. And that, for me, is incredibly important. The mistaken public position of the PSNI abusing covert measures against journalists and lawyers has come from what's described in the report as a compounding or snowballing effect, as Mr. McCulloch described in his letter of introduction to me. Firstly, an assumption that lamentable failures in the Operation Yurta investigation, and in particular the unlawful treatment of Mr. Burney and Mr. Caffrey, as being the tip of the iceberg. Secondly, the number of communications data applications relating to journalists and lawyers in the June 2024 PSNI report to the Policing Board gives a misleading impression of the scope of the use of powers. This has been misinterpreted and has been misreported. Thirdly, a misrepresentation of a redacted meeting note produced in the Burney and McCaffrey IPT case, which was mistakenly taken to be a list of 8 journalists who have been allegedly the subject of routine surveillance. Fourthly, historical serious intrusion by state authorities, including before there was statutory regulation on these issues. And fifth, limitations in statutory remedies to provide positive answers to concerns in the realm of covert procedures, and the general policy of neither confirming or denying the alleged use of such measures in any case. The report provides an excellent platform for improvements within this organisation. A future updated review by Mr. McCulloch will take place to ensure that we've sufficiently responded to and implemented the recommendations in the report. And this will also allow time for him to take account of the outcomes of any ongoing IPT proceedings. I am a huge advocate, as many people know, for openness and transparency in policing, even in the arena of covert measures where we can do this, and especially where legitimate public concerns are expressed. Sunlight truly is the best disinfectant. It ensures we improve where we need to. This comprehensive report sets out that no evidence exists of the abuse of those powers by the PSNI, but that our processes in the application of these powers needs to improve, and that, I can assure you, will happen. And after the Chair has spoken, I look forward to taking any questions.
Thanks, Chief Constable. Can I hand over to the Chair, Mukesh Sharma? Thank you.
Thank you, Sinead, and thank you, Mr. McCulloch and Chief Constable, for your opening remarks. The Board welcomes the McCulloch Review, which provides a detailed assessment of the activities and actions of the PSNI in respect of surveillance of journalists, lawyers and others of special status. The Board welcomes the approach taken by the Chief Constable and his senior team in relation to the commissioning of this report and the access afforded to the reviewer. We acknowledge that the opening up of this aspect of policing in this way is unprecedented. The report outlines practices that represent failures by policing in meeting the strict legislative provisions for the use of surveillance powers and complying with the principles of accountability, proportionality and respect for press freedom. It raises particular questions around the efficacy of the systems used by the PSNI and the impact this has had on the candour with which the PSNI has engaged in scrutiny and accountability process by external reviewers, authorising procedures, the accountability of authorising officers, the adequacy of existing oversight by appointed reviewers, disclosure processes and tribunal proceedings, and with other statutory bodies, including the Policing Board. The police necessarily have access to powers, including intrusive powers. These powers keep us all safe. However, there must be protections and safeguard for their use. Policing can never be above the law, and the public rightly expect that they comply with it at all times. The report and its recommendations also send an important message to other policing and law enforcement institutions who use such powers. Since the issues around surveillance first came to light in 2023, very active steps have been taken by the Policing Board to try to bring openness and to try to bring transparency to media and other concerns being raised through cases at the Investigatory Powers Tribunal. In June 2024, the Chief Constable's second report to the Board did not provide the assurances needed, and we clearly told the Chief Constable that it did not. As a result of the Board's ongoing scrutiny, the Chief Constable commissioned the McCulloch Review, and the Board subsequently agreed that this report would be treated as a Section 59 report under the Police Northern Ireland Act 2000 legislation. So serious was the issue viewed at that time that for the first time the Board opted to use this Section 59 power. Yesterday, the Board convened a special meeting with Mr McCulloch and with the Chief Constable to have an initial discussion on the findings and the conduct of the review against the terms of reference that were set. The Board now wishes to take some time to review the report's findings and to receive a formal response from the Chief Constable on remedial action and plans for formal implementation of the recommendations which are now made, before taking a decision on the next steps. We want to ensure, as the report says, that our next steps will enable PSNI to achieve consistently high standards in this area of policing and to enable confidence in PSNI conduct in this area. In terms of those next steps, we have ruled nothing in or out at this stage. The Board wanted the report to be published as soon as possible so that there is transparency on what has been found. Trust between the public, the media, the legal profession and policing institutions is paramount. This report shines a light on how that has been damaged, and policing now has a job of work to do to restore confidence. The Board has agreed that this report and its findings are extremely serious and will now seek to ensure the step change outlined by the Chief Constable in our meeting yesterday remains a key focus for the service until it is delivered. As a Board, we thank Mr McCulloch and his team for their work in progressing the review and the recommendations made to date. I also thank the group of external stakeholders for their assistance in the review. As already stated, the Board will now convene a meeting to consider this matter further. Thank you.
Thank you, Mikesh. Okay, we're going to turn to Q&A here. I have a list of various outlets, so I'm going to take them in the order it's been given to me. So, James Gould from Downtown Cool FM.
Good afternoon, Chief Constable. Just on press freedom, how do you plan on regaining that trust with the public? And also, could you clarify the actions taken against the social action?
So, I'll deal with the first question. I've made it clear since I arrived here, and there's quite a list of things in the in-tray which were well documented when I was appointed. This wasn't spoken about, but it was one I identified pretty quickly. The 2024 report that the Chairman just referred to was actually probably a significant shift in the transparency of information, noting the Chair's comments about the PSNI giving information around covert activity. The report was done very quickly, but was a document that provided details that had never been given before around how we conduct covert activity and the data, the statistics, the information of what we do. It was part of this journey, and then the appointment of Mr. McCulloch with his significant experience as a senior special advocate in dealing with sensitive information, sensitive matters, was again, I think, a demonstration of the direction of travel and the commitment that we have, that I have and the organisation, my colleagues have. And this report, I think, is a tangible example of us showing that we are determined to be where we can be in the very nature of covert policing and what we need to do to protect society, transparent about how we do what we do. So I think this is a landmark report. I cannot impress upon people how impressive the work is, how thorough it is. There has been, in my view, this unprecedented level of access, which is the right thing to do. It's simply what we should do, and we've done it. With regards to Donald McIntyre, I'm writing to all of the people who are named in the report that I agreed, as Mr. McCulloch has explained, should be contacted. And at the very beginning of the process, by the way, it's been something of an interesting journey as to how we deal with any findings that we got things wrong. And I made it very clear that my view is we needed to tell people if we got things wrong. The report pretty forensically sets out what happened in that case, and it stems from actually the amount of speculation there was in the public domain about what happened to this poor 14-year-old boy. And I'm very conscious that that case, it's an ongoing inquest, and you know the impact on the family of not just what happened, but then the speculation and reporting online. And there are efforts by various judicial bodies, rightfully, to try to moderate that because of prejudice and ensure that legal processes could occur with impartiality and objectivity. So I'll speak to Mr. McIntyre privately around what we did. I think it is important to reassure you and people here that as the report sets out, we publicly searched what had happened on Twitter and the reporting. No risk of getting any confidential information from what I've seen from the report. But the authorization and what we didn't happen as it should have happened. We made a mistake. And that is completely on me to put right. And the report, in a very transparent way, sets that out. And we didn't then refer that matter to IPCO, who are the body that come to oversee and inspect us around covert authorities, which obviously has been done. And we should have highlighted that case to IPCO. So again, we didn't get that right, but we've learned from it. And I think as Mr. McCulloch described, we're determined that the experiences of these people and the report mean that these things won't happen again.
Okay, thanks, James, for the question. Thanks, Chief Constable. Next one from Julian O'Neill, BBC.
Good afternoon. Chief Constable, I want to ask you about the practice whereby journalists' phone numbers, which had been probably given to your press office, were unknowingly used by the PSNI to cross-check against staff at the PSNI's phone numbers. When you raised this issue, or when you came to the board last year, you talked about that behaviour being lawful business monitoring. You also said it was a mischaracterisation to say it was an offensive operation directed towards journalists. Given what Mr. McCulloch has found in his report, do you need to reflect upon those words? Did you misinform the board, given that Mr. McCulloch says that that is an accurate description and given the fact that he says that the PSNI did not seek any legal advice whatsoever in relation to the legality or propriety of that practice?
So firstly, lawful business monitoring, I have a view on it, but there is a statutory basis for organisations, including the PSNI, to monitor communications that they have on their systems. And this is about monitoring any inappropriate contact between members of staff and journalists. Our own staff are informed that those communication systems that we own, our own telephone system and our own telephones, mobile telephones, can be subject to that monitoring. So it's a well-known issue with our staff. I don't think blanket searching of journalist numbers should have occurred. It hasn't occurred since I've been here. It stopped, I think, in March 2023. There was a formal and definitive statement that it would no longer happen last year. And I have made the decision that those lists will be deleted and that will not happen again. I don't think it's proportionate, but I do have to reinforce that legally it is able to occur. But it should be that we only search for information, in my view, where there is a specific case involved, where we have information, not do these blanket searches. So that's, again, part of the benefits of the report. We had stopped that process, and I'm pleased that Mr. McCulloch has highlighted it in a way that I think others can learn from with regards to what had occurred previously.
Do you know why no legal advice was sought by the PSNI and why you characterise it as lawful business monitoring?
So it's been characterised as that. I can't give you, sitting here, an explanation about where that name comes from, but it is lawful, but I don't think necessarily it should be done. You know,
Is it lawful with all due respect to the Constable? Because Mr. McCulloch doesn't offer a definitive position on it for good reason, because he said it may be subject to legal challenge, but he does appear to place a huge question mark over the legality and propriety of this, including in respect of data protection.
So legally, I don't think, and Mr. McCulloch's been very careful in what he said, he's not a judicial body. He can't say whether something is lawful or not. He's talked about unlikely to be unlawful. So neither can I. What I can tell you is the practice has stopped. The issue around legal advice, this has happened from many years ago. It's not happened, as has been set out in the report, since the dates provided by Mr. McCulloch, which was, I think it was March 2023, but you may have it to hand. It's not happening anymore. And in my view, it shouldn't happen in the broad way it has happened. But I think there is a basis for organisations to do it legally. That's my understanding. But I don't think it's helpful. I think it has to be, we've got incredible frameworks for dealing with how we should operate around proportionality, necessity. And that is something that I think is far too broad a brush. You need to have specifics about why you would do some searches like that around concerns around people, in my view.
Okay, thanks, Julian. Next question from Johnny McCambridge, Press Association. Johnny.
Chief Constable, we've spoken a lot today, we've heard a lot about the McCaffrey-Burley case and the importance of that case and because of in relation to everything else we're talking about today. Can you perhaps give some explanation to how, until quite recently, digital files from the devices seized by police were still in possession of the PSNI, and what does that say about the, I suppose, learning lessons from that case?
So there's a limited amount what I can say, because I've offered to meet both of them, and I think it's important that I speak to them about it. In effect, there was a mirroring of the material on a system so that it could be looked at more easily. And when the court ordered, as I understand it, this is my understanding of the position, when the court rightfully ordered for the material to be destroyed, the material was destroyed that was seized on the original systems, but we failed to recognise that this mirroring had occurred. Again, one of the benefits of this review and Mr. McCulloch's work is that he realised that was the position, and I can say that the material had not been accessed, looked at, searched. It had just sat there in this mirrored state on a system so that you could actually read it better. And we destroyed it, and we notified both Mr. McCaffrey and Mr. Burney of that position, and we notified the court. So this is another benefit of the importance of this sort of examination. And I apologise for that having happened, because it shouldn't have happened.
Okay, thank you, Chief Constable. Next question from Chris Page, BBC. Chris? Oh, yes, sorry.
Chief Constable, you've reiterated your apologies to Trevor Burney and Mary McCaffrey. You've also said you've written to some of the people most affected by the issues under scrutiny in this report. Can I ask, have you made any more apologies to individuals as a result of what Mr. McCulloch has found?
So, because of the timing of this process, it was important, I think, that Mr. McCulloch wrote to those individuals first. So on the foot of that, they've now received letters from me, setting out that I'd agreed that, obviously, with Mr. McCulloch, they should be contacted by him. And I'm seeking to meet those individuals, and I'll speak to them personally.
Okay, thank you. Next one from Sarah O'Kane, UTV.
Good afternoon, Chief Constable. Just to pick up on what Chris Page has said there, we are aware that you have written to some of the journalists affected, some of those actually in UTV's newsroom. Are you prepared to apologise now and say that this was wrong?
Well, of course I accept. I've said, I think here, I've not been clear enough about it. I do apologise for any instances where we have obtained data and not done everything that we should have done with regards to the considerations for those processes. This is about processes. This is about making sure that all the considerations around journalistic material, LPP with regards to lawyers, legal privilege material, that we are absolutely fastidious in making sure that we properly consider any risks of obtaining information that we should consider as protected. And it's reassuring that since 2015, 10 years ago, Mr. McCulloch explained, and it's in the report, we've not sought any of that information for a journalist source. We haven't. But we need to make sure that what we've done in the past, those lessons are learned. The headline from this is, and I did mention in my opening remarks, it's easy to get caught up in the rightful outlining of processes that have failed, but there has been no systemic abuse of covert powers by the PSNI from what I can see. And we have deliberately and specifically ensured that everything was looked at. And I expected to find errors in process. I would expect this to happen with any other big organisation that has to deal with the threats that we have to society today. It's a real challenge, but we've got to make sure now that we work really hard to deliver on the recommendations in such a thorough way that when Mr. McCulloch returns, there is, and it's part of the journey I talked about, an absolute reassurance that we're doing this as well as it can possibly be done. So I apologise for any sense of unfairness or injustice in getting any data that this review has showed that we hadn't properly considered all the legal intricacies of what we should have done.
Chief Constable, I think when we do look at some of the detail and this practice, and I know it's not happening now, washing through journalists' phone numbers, why are you so concerned, or why is the PSNI so concerned about leaks? And can you sit there with your long career and say you never handed over a bit of information to a journalist?
So there's such an amount of really sensitive information and data that we have, that we hold. And as in any organisation, whatever profession it might be, there will be times when people will let the organisation down and will reveal information that they shouldn't do. my posture on that is where we think that's happening, we should investigate it. But we shouldn't apply the broad brush that I think has been applied in this case, which, by the way, I think has happened for time immemorial in police services and other agencies. And my expectation is in the future there may be some more precise, and this goes to Julian's question, guidance or legal case that will specify, I think more helpfully, about when that should occur and when it should not occur. So, look, it's what had happened. It's not happening anymore. And hopefully that's a reassurance to all of you.
Okay, thank you. Bill Goodwin, Computer Weekly.
Yes, I'd like to ask Mr. McCulloch what he considers the most urgent and important recommendations are that he's made. And I'd like to ask Mr. Butcher whether the PSNI has the resources needed to make all of the recommendations, and for example, to be able to fix outdated computer systems that Mr. McCulloch examined and had difficulty finding information from because they were old and slow.
Okay, thank you. Angus, do you want to take that first?
Thank you, Mr. Goodwin. I think I would struggle to put them into a list of priorities, and I don't think it's necessary to do so. These things can be addressed in parallel, and in my view should be addressed in parallel. Some will take longer to implement than others, but that's not a reason not to be embarking upon all of them at once. And it's very reassuring to hear the Chief Constable indicating that that is precisely what is proposed. So at the risk of sidestepping your question, I don't think it's helpful necessarily to try and put the recommendations in an order of priority. They should all be treated as a priority, and some will take longer than others.
Just to probably expand on Mr. McCulloch's answer, as far as the recommendations are concerned, anything where we are required by Mr. McCulloch to inform IPCO or the Information Commissioner about any of the activity that he has found, that has all been done. I'm really grateful for your question about recommendation 7, because we have got antiquated systems. The board are there to advocate for the resources for the PSNI. This is about the issues that have been identified in the report, this press conference. But we need capital investment to ensure that we can have systems like other policing and law enforcement organisations to properly search those systems. We need to back record convert onto a system that we can all have confidence. And I know Mr. McCulloch will have had real challenges in searching the systems, but had the time to do so properly, to be reassured that when we are asked for information, that we're able to properly provide courts and legal bodies with assurances that we've got all of the information. There is a need for that capital investment, and that goes hand in glove with the fact that we need the resources to police Northern Ireland properly, which we do not have and have not been provided. But this isn't, I don't want to get distracted on that. The recommendations other than recommendation 7, I am confident, and it's on me, it's my responsibility, it's my burden, supported by my senior team, that we deliver all of those recommendations in a speedy and fulsome fashion, which is what I'm confident we'll be able to do. But recommendation 7, as you perceptively highlight, can I say, is a challenge, but we will find a way to do that.
Okay, thank you. Thanks for the question. Next one, Curtis Reid, Belfast Telegraph.
So very quickly, the review in regards to the washing of journalists' numbers, the review recommends the PSNI refer that practice to the Information.
Yeah, no, in accordance with my last comments, any recommendations from Mr. McCulloch that we refer cases to the Information Commissioner or IPCO, that's all been done. So they've been done. Okay.
Thank you. Mark O'Driscoll, RTE. Oh, that's right, he left. Sorry. We'll come back. Amanda Ferguson, Reuters.